If you'd like to ask a question, you can simply put your question in the chat box, which is, if you hover over the lower screen, you'll see a little chat icon. Or if you like, you can click on the participants button, and during the question and answer period, we will be able to answer your questions at that time. Now, I do want to ask Audrey and Ken if they would like to have questions as they come up, or how would you like us to deal with the questions?
We're very easy, Karen. I mean, I'm always happy to try to engage in a discussion. There may be questions that arise that will be answered during the course of the presentation, and we might politely ask if you hold on if we are going to come to it.
In the presentation, great. So Carrie, would you like, I hand it back to you, or shall we just go straight into the presentation?
Well, I'm just very honored that Ken and Audrey have agreed to present, taking time out of their busy schedule. Ken Kramer is the founder and principal of KMK Law, and Audrey Jun is the associate. And I'm really interested in this topic because I just entered into being a rep for my older sister, and I don't know how happy she is about that. But anyway, we'll leave it over to you and Ken and Audrey.
Great. Thank you, Carrie and Karen. First of all, I just want to pass along what a pleasure it is to be invited back. Many of your members of the audience may have attended last month's workshop around estates and trust and disability planning. And so I'm very honored to be invited back, and really excited to have one of my great associates, Audrey, joining us. And I'm really honored to be able to introduce her to the families of SFI or FSI, and to provide her insight on this area of representation agreements and other personal planning tools. I'm going to let Audrey take a moment just to introduce herself.
Thanks, Ken. I really wish I could emphasize more just the amazing background and experience that Ken has in this field. I know he likes to gloss over it sometimes, but he's an amazing person and really experienced in the areas of elder and disability law. Just briefly, I'm an associate at Ken's firm, again, specializing in estates and trust matters. We serve lots of families with disabilities and their unique needs. I have presented at a number of conferences before, but this is my first time with FSI, so I'm really glad to have this opportunity. I have been a former board member for NIDIS Personal Planning Resource Center, which many of you may have heard of, and I'm currently an active director with FACO BC. So without further ado, Ken, unless you have anything additional to say, should we move on to the presentation?
Absolutely, let's do that, Audrey. So we're gonna effectively tag team here a little bit, and I'm gonna start us off. We always think it's important to have a sense of, you know, what are the outcomes, what are the learning objectives for tonight, so that everybody's really clear. We definitely wanna speak and differentiate tonight between representation agreements and powers of attorneys. And within the area of representation agreements, we're going to talk about the differences between the Section 7 and the Section 9 representation agreements. We're going to talk a little bit about the importance and relevance of capacity. And capacity really plays a central role in developing personal planning documents. And that's really important for families where there may be developmental related challenges. We're also going to talk very briefly about private committeeship and what that means, and really emphasize that it is a last resort option, and the other vehicles on that outcomes basis are actually the vehicles we really want to emphasize our time on. And that's why we want to make sure that you're well-versed, well-briefed on some of the vehicles that are available that are going to assist you and your family. So what is personal planning? It's not estate planning. So for those that attended last month's session, most of the focus was on estate planning. And we're going to talk about personal planning, which is planning for while you're alive and understanding that these documents that we're going to discuss are going to die with you. So we're going to focus on several documents. Obviously, again, the representation agreement, the enduring power of attorney, advanced care directives, and a number of other documents. And then again, a friendly reminder that estate planning only is relevant after death. This is where we talk about wills and other estate planning documents. So in British Columbia, when we're talking about personal planning tools to support decision making, there's a presumption that everybody has capability to make decisions when they turn 19. And 19 is, of course, the age when we become an adult, and we're deemed to have capacity. Now, of course, this is not always the case, and there are numerous reasons of potential incapacity at the age of 19. Again, very much relevant to the audience today or tonight in terms of family members that may have developmental related challenges. So it's important to understand that capacity is transaction specific, and that there is a general nature and effect test in place. Some individuals may never be considered capable under the law for specific transactions, whereas others may have the ability or may lose it over time due to aging, disease, or accidents. So there are many tools to plan for incapacity, end of life, and or overall support needs. So we're going to focus initially on the enduring power of attorney. And again, it's a living document. It dies when you die. And its fundamental purpose is to enable an individual, an adult, to appoint a person or persons to be your attorney, to assist you or make decisions relating to legal and financial affairs for that adult. And that power may endure if you later lose mental capacity, and that's what we commonly refer to, which I'll talk about in a moment, the enduring power of attorney. The one big important characteristic of an enduring power of attorney is that there is a very high test for mental capacity. You must be able to understand the nature and consequences of that document. And so this test of capacity is very, very similar to what we might have with respect to the development of a will. Now, within the category of powers of attorneys, there are a number of different types. Of course, there's the general power of attorney, which may include broad powers to handle financial and legal affairs, but that power will end if the donor of the power becomes mentally incapable. There are also, for many folks, they'll develop powers of attorneys within their financial institutions, And typically those bank-related powers of attorney are really limited to specific tasks, typically within the financial institution, or perhaps for a one-time transaction, such as selling a property, for example. The more common power of attorney, of course, is the enduring power of attorney, which includes the same broad powers that we see in the general power of attorney. But the one caveat is that it does not end if the donor of that power of attorney becomes mentally incapable due to illness, disease, or accident. So you may have a power of attorney that is valid while you're of capacity, but it will also continue to be valid when you lose capacity, which is the enduring mechanism up until the date of death. So a power of attorney is a really important tool. And for many clients where capacity is not in question, the power of attorney can serve as a very important insurance vehicle to protect against incapacity. And a great example of this is where spouses jointly own their home and one of those spouses becomes incapable, which then restricts the other spouse's ability to sell that. Oops. Yeah, I wonder if we could ask everybody to just mute their speakers so we can't hear you.
Terry, you can mute everyone and then unmute himself.
That'd be great. Thank you. Yeah, if everybody can just mute your microphones, and then we won't be able to hear you. There we go. So back to the example where spouses are joint owners of a home. If one of those spouses were to become incapacitated on a jointly held property, the other spouse would not be able to manage that property because both parties would need to consent. So if there was, let's say, a need to sell that house, refinance that house, the other spouse would not be able to do this without a power of attorney. And if there wasn't a power of attorney in place, they would then be stuck with potentially having to apply to court to be appointed private committee, which we're going to discuss a little bit later. So having that power of attorney can actually avoid some really significant developments where one of those joint owners becomes incapacitated at a later point in time. Now, obviously, one of the questions that comes up is, who can you appoint as your attorney? And really, there is no limitation. You can appoint a spouse, children, friends, relatives, perhaps even a trust company or a financial institution or a professional, such as an accountant or a lawyer. The one caveat is, of course, that professional attorneys will charge fees, and usually there is a fee agreement in place to substantiate that arrangement. That doesn't mean, of course, that your other attorneys won't be entitled to fees, and under the Power of Attorney and Trustee Act, there are provisions for attorneys to be compensated as an attorney. So there are a lot of things to think about when you're appointing an attorney in that regards, and obviously fees are an important element of taking on that role. So the duties of an attorney are significant, and I think there is an assumption out there that when you're appointed an attorney that somehow it equates to being an honor. And the reality is that the role of attorney is definitely not an honor. It is a huge undertaking. And there is a huge fiduciary obligation on attorneys to act honestly, in good faith, to exercise the care, diligence, and skill of a reasonably prudent person, and to act within the authority given under that power of attorney, to keep records for inspection, etc. So it's important for the attorney to also recognize that they have a duty to act in the adult's best interest. Taking into account not only the terms of the power of attorney itself, but also the adult's current wishes, their beliefs and values, and of course, any directions that were outlined in that document. So, when managing those affairs, it's important to give priority to meeting the personal and healthcare needs of the adult, fostering their independence, and involving them in decision making that may impact them, and not to take advantage of that role, or to make a transaction that might benefit the attorney. Their main focus is to do what's in the best interest of the adult, and to abide by the laws and rules associated with that. So, with that responsibility comes great risk. And that's why when someone is appointed in this capacity, it's absolutely vital that they understand what their duties are. Okay, I'm going to turn it over to Audrey now, and Audrey's going to run us through the representation agreements.
Thanks, Ken. So first of all, I just want to make it really clear, we're really lucky in BC to have the Representation Agreement Act. It's a really unique piece of legislation, and it's been recognized internationally for being a really innovative piece of law. So this law recognizes that although some adults may not be capable in the traditional sense, for example, for being able to enter into contracts or making a will, and although their mental capability might be in question, that this adult might still have a way to legally appoint persons they trust to help them with decision making. So there, as you can see on the screen, there's two different types of representation agreements. So for people such as myself, and likely most people here in the audience today, we would be able to make a Section 9 representation agreement, or the RA9. So with the RA9, I can appoint people to help me make decisions or to make decisions on my behalf regarding almost all healthcare and personal care matters that someone can give, in a document. However, in order to make that, I have to be considered mentally capable of understanding the nature and effect of the document when I do make it. On the other hand, for adults whose capability is in question, for example, adults who have special needs or an intellectual disability, or an adult who has developed advanced dementia or has had a stroke, they may still be considered to have the ability to make a Section 7 representation agreement, or as I'll refer to it, an RA7. The RA7 can allow the adult making the document to give people they trust the legal authority to help them make decisions in all life areas with some limitations. So this next slide provides some examples of what you can authorize your representative to do within either type of representation agreement. Again, let's say I'm making a representation agreement Section 9. I'm likely going to be making it together with an enduring power of attorney, which Ken talked about, which covers me for financial and legal affairs, while the RA9 is going to be covering me for my healthcare and personal care matters for the broadest total coverage. With the RA9, in addition to minor and major healthcare matters and personal care matters, I can also authorize my representative to refuse care for life-saving treatment, authorize them to give or refuse consent to some specialized medical procedures, and also, if I have children, I can authorize my representative to make arrangements for the temporary care of my minor children. For example, if I'm going to be hospitalized for a long period of time and won't be able to take care of them. On the other hand, for an individual who's looking at making an RA7, this is likely going to be a situation where they may not be considered capable of making an enduring power of attorney. However, the RA7 does cover routine financial affairs and some legal services. For example, the adult making the RA7 can authorize someone to help them with paying their bills, setting up an RDSP, that's a registered disability savings plan for them, communicating with Canada Revenue Agency, arranging for dental visits, consenting to medications, and also making decisions about living arrangements. So it's really, quite a lot in there, a really helpful document. However, there are some limitations with both. So first of all, you may have heard of MAID, which stands for Medical Assistance in Dying. We'll briefly go over this later, but in short, you can't authorize anyone using a representation agreement, either a Section 9 or a Section 7, to make a decision about medical assistance in dying on your behalf. That's just not possible. Just also a friendly reminder that the Section 9 does not deal with financial or legal affairs at all. That would be with the enduring power of attorney. With the Section 7 representation agreement, there are some limitations that would not exist with the RA9 and enduring power of attorney combo. So for example, Section 7 cannot authorize the reps to deal with real property, so selling real estate, and it cannot authorize, specific healthcare decisions that may be authorized in a Section 9 representation agreement. And I've listed a few there. Giving or refusing consent to life-supporting care, abortion, experimental surgery, a few different specialized types of healthcare decisions. So similarly to the Power of Attorney Act, the Representation Agreement Act provides duties of a representative at Section 16. We've pulled out a few points here. This is not an exhaustive list, but in general, representatives have a duty to act honestly, fairly, and prudently, and within the ambit of the authority given in the agreement. The representative still has a duty to consult as much as is reasonably possible with the person who's made the document to determine their current wishes, and if they're able to determine them, they must comply with those wishes if it is reasonable to do so. And depending on the situation, they must comply with wishes or instructions that the adult expressed while capable. And even if this is not available, they must act on the basis of the adult's known beliefs and values, and as a last resort, in the adult's best interests. Again, representatives have a lot of duties, so while this is, kind of an honor, sometimes it really isn't because of the amount of responsibilities that a representative has. So representatives also have a duty to keep accounts and records regarding the exercise of their authority. So, for example, you could do this in a journal or a notebook by writing down dates, describing circumstances, listing people involved, for example, the dentist's name or the doctor's name, the decision you made or action that you took on their behalf and why. You must keep copies of records that the adults made of their instructions, wishes and beliefs and values, and a record of changes to where they live or whether you authorized any other personal care decisions. And if you're appointed in a Section 7 representation agreement and you're dealing with financial matters, for example, You must make reasonable efforts to keep records on the adult's assets and liabilities. For example, their bank statements, receipts, bills, and so on and so forth. So again, there's many duties here. If you're appointed, it'd be very important to take a look at Section 16 of the Representation Agreement Act. So how do you make a representation agreement? Section 13 provides a good overview. So the adult, the representative, and the monitor is usually a role reserved for Section 7 representation agreements, must all sign the agreement before the representative can act. And the adult must sign in the presence of 2 witnesses unless they're signing with a lawyer or a notary. Let's say if one of the adults, has a physical disability and they can't physically sign, that's fine. There are options. So if they're physically present and they direct that the agreement be signed on their behalf, there's options to do so. There are restrictions on who can act as a witness. For example, you can't have a minor acting as a witness. You can't have somebody appointed or their close relative. And these restrictions also extend to who can be appointed as a representative. So the representative must also be 19 years old, at least 19 years old or older. They can't be in conflict. So you can't appoint a paid caregiver unless they're also your spouse, parent, or child. You can't appoint an employee of a facility where you live and receive care services, again, unless they're your spouse, parent, or child. And back to sort of the specifics of signing, the reps don't have to be present or sign at the same time as the adult. So the only people that really have to be present at the time of signing is the adults making the agreement and the witnesses. So if the representatives are signing separately, you have to ensure that they sign after the adult has already signed, but they can sign in counterpart, which just means that they can sign on a separate copy of the page of the document that asks for their signature. So there are other.
Audrey, I just have a couple of questions. So you don't require a monitor for a rep agreement. That's not a requirement?
That's generally done for Section 7s. For Section 9, that wouldn't be. It's quite an important role because what the monitor does is, in the case of a Section 7, if there are financial records, along with the PGT, a monitor has the ability to request those records, and they kind of act as that objective third party who's able to say, okay, everything is going well, really recognizing that the adult might be in a vulnerable position. And so that's a really key part of the Section 7 agreement. And when we get to resources,
sorry. Oh, I agree in Section 7 you should have a monitor, but I keep getting asked, is it a requirement? No.
I would have to, I've always seen it. I would have to refer to the legislation again to see if it's a strict requirement, but Ken, did you have something to add?
Yeah, I don't believe it's mandatory. That's my understanding, although, I've, like you, Audrey, I see it more commonly in the Section 7, but I don't believe there is a requirement that a monitor must be appointed as part of a Section 7 agreement. But that is definitely something we are happy to confirm and get back to you on.
That would be great. And then the other question that I've had from people before this meeting is, if you are paid to support the person, our understanding, although somebody's asked, is it in legislation, you can't be a rep. Is that correct?
Sorry, could you repeat that?
So
I was just.
We've got a situation where the sister is being paid to provide service to her sister, but she's also a rep.
Right, so siblings aren't covered. So if you're a spouse, parent, or child, You can be appointed even if you are being paid for caregiver services, but that doesn't extend to siblings.
Okay, so that's in legislation though, because this woman is a lawyer and says she wants to see the policy.
Well, it's not policy, it would be the legislation.
Legislation, okay. Thank you.
Thank you, Carrie. Okay, so just moving on to some other planning options. So there is also a document that you can make, a legal document called an advance directive. So that is a document where you can give or refuse consent to specific healthcare matters. It's quite limited in its use because your instructions have to be just absolutely clear. It needs to specifically articulate and apply to the specific healthcare situation that you find yourself in at the time that the healthcare provider is looking for your consent. Important note here that the representation agreement is more powerful than the advance directive. So if they have both, for example, generally the healthcare provider is going to defer to the representative appointed in the representation agreement. However, if the adult has made both, the representation agreement can also state that the healthcare provider must act in accordance with the instruction in the advance directive without the consent of the representative if that advance directive specifically applies to the situation at hand. So there's a caveat. The reason why I generally don't recommend this is that it's just a really inflexible document. Something that clients have also told me is, I thought I would want X, Y, and Z, but now with the COVID situation, actually I'm reconsidering. So just like COVID, there will be situations that come up in the future where everything changes, the rules kind of turn upside down. Things are happening that you'd never considered before. And that's the beauty of the representation agreement, where you can appoint somebody who you can continually talk to about your values and beliefs, who understands that you may act differently depending on the context or situation, and who you can talk about your evolving wishes with. Whereas the advance directive is really just sort of very rigid, doesn't take into consideration different contexts necessarily, and is not really an evolving document. If you're looking at doing organ or body donation for research, which you'd like to do for research or education purposes, you must give consent for this while you're capable of understanding what you're doing, and you must register with BC Transplant's Organ Donor Registry, which you can do at transplant.bc.ca. And finally, as we mentioned previously, MAID, medical assistance in dying, is really outside the scope of our presentation today. But just briefly, currently in Canada, physicians and some nurse practitioners, depending on the province, can provide medical assistance in dying services while strictly following both federal and provincial laws. No one can be forced to provide or help provide MAID, and in order to be eligible, you must be at least 18 years old and mentally competent, or being capable of making healthcare decisions for yourself. You must have a grievous and irremediable medical condition, make a voluntary request for MAID that is not the result of outside pressure or influence, and give informed consent to receive MAID. You cannot authorize somebody else to request MAID on your behalf. All right, so in the past slides, we've talked mostly about enduring powers of attorneys and representation agreements, which are really planning tools that you can use to avoid as much as possible commutation. So commutation is when somebody is appointed by the court to make decisions about potentially all of your affairs. It's quite an invasive process, and it's considered a last resort measure when all other avenues have already been exhausted. You may also hear the term adult guardianship or statutory guardianship, and this is the term used when the PGT, or the Public Guardian and Trustee of BC, which is a public and government body, takes over the financial and legal affairs after medical assessments are done, and a certificate of incapability is issued by the health authority. So for the PGT, that's a statutory power rather than a process of going through the courts. And usually when the PGT determines that you are incapable and need help and no one else is available to help you, or no one else is suitable to help you, will they step in?
Audrey, I just have a question on this topic you're discussing right now from Angela. And she's asking, what are the stipulations on representation agreements and PGT with considerable assets in trust from a personal injury case? I was told by the PGT this morning that I would need to do a committeeship.
Let me just see if I can read the comment.
Yeah, it's in the chat from Angela.
It's a little bit hard to say without knowing the specific facets of the case. I will just say they're probably dealing with, I'm guessing she's referring to a Section 7 representation agreement, because that's the only one which deals with financial issues, and she's talking about assets. Depending on the situation, it's possible that a trust has been set up where they have a stipulation in the trust that when this person turns 19, they have to apply to the court to have the court determine whether this individual is either capable or incapable. Otherwise, under the terms of the trust, the adults may be determined to be able to exercise some kind of control over the trust assets, and they want to ensure that the court makes that determination so that there's no concerns about an incapable adult being influenced by others or something like that, and exercising control over trust assets. That's my guess. But I don't know the specifics of that case. Ken, do you have anything else to add?
Yeah, I mean, I think it's a really good question, Angela, and I think that, obviously we would need to have a little bit more information, but there may be some limitations if there is a Section 7 agreement in terms of whether the receipt of that settlement, the personal injury settlement, falls within the ambit of routine financial matters. And so the PGT, it sounds like they've requested committeeship. And obviously, to proceed with that is obviously going to change significantly the life of that individual with a disability. And so committeeship, I would say has implications beyond the settlement itself. And I would definitely encourage you to get at least some preliminary legal advice before you embark on committeeship, because there may be potentially other remedies available, again, depending on capacity and what has resulted in that settlement now coming into fruition. So there are a number of potential factors that may be relevant here that we're not aware of. So yeah, hopefully that's helpful.
Okay, so let's say you have
one more quick comment. She says she's tried a few lawyers in our area, but nobody in my area works with this. So Angela, perhaps maybe you can connect with Ken after this call.
Yeah, we'd be happy to chat, Angela. So please reach out to us. We can even have a bit of an initial consultation without any obligation on your side.
That would be great. I'd really, really appreciate it, because today my head is just spinning after talking with the PGT and kind of just feeling a little frustrated that, after 18 years of looking after him and going through all the medical stuff that I'm going to have to figure out a way to come up with the cost for the committeeship. And yeah, I feel a little overwhelmed today. So today couldn't have come at a better time with all of this stuff. So
Absolutely. So yeah, give us a reach out to us in the coming days. We're happy to see if we can help you through that.
that would be great. Thank you.
One more quick question, Audrey, before you carry on, from Jennifer, asking, the ministry stated that a rep agreement and or a power of attorney is needed for prescribed class PWD application. When child turns 19, she will still not be able to communicate or sign docs.
So the ministry, of course, recognizes a representation agreement. And one of the great things about not only the ministry or organizations like CLBC, they appreciate that there may be diminished capacity. Whether or not there's an ability to develop a POA, it's hard for me to say without obviously having more knowledge. But clearly, the Section 7 agreement, which Audrey spoke of earlier, where there is routine financial matters, and I consider the PWD process a routine matter, should be able to be facilitated with a Section 7 agreement when that child turns 19 and is an adult.
All right. Thank you, Ken. So let's say, for example, that you haven't planned by making a representation agreement and an enduring power of attorney, or you are incapable of making either of those documents, and the RA7 is insufficient for some purpose. For example, if some real estate you own needs to be sold to pay for care fees, a family member or a friend can apply to the court to become your comité. This procedure is quite expensive, as you can see, and can cost thousands of dollars. Again, if there's no one able to act, let's say the PGT receives reports that somebody is living alone and potentially a victim of financial abuse, they may step in themselves and ask for an assessment from a qualified healthcare provider and start the guardianship process. So the comitationship procedure, should it have to be undertaken, has several steps involved and includes, but is not limited to, the following. So 2 medical affidavits need to be sworn by 2 different physicians saying that the person is incapable of managing either or both their person or estate. Physicians do charge fees for this service, and they can range, there's a huge range, so they can range from $300 to upwards of $2,000, depending on if it's a family physician or a specialist. The person who's applying, or the persons who are applying, also have to swear an affidavit themselves. They need to demonstrate their qualifications to act in this role. They also need to provide personal information about the patient, their age, living arrangements, what assets they own, what debts they have. And in some cases, they may also need to provide an outline of a care plan for the patient. The public guardian and trustee also reviews the application. Currently, the statutory fee to do this is $525. So again, there's a lot of different fees from different parties here. You also, if you're applying, have a duty to notify certain individuals, so next of kin of the adult, people who have been appointed in a power of attorney or representation agreement. So once they're notified, individuals can submit competing applications, and this will increase the complexity and cost of the case. So depending on how simple or how complex the process is, it can take 3 to 4 months or longer, really depending on the facts of the case.
Audrey, if I could just ask a quick question. Eve was asking a question about what ministry is being referred to. In your last comments, Ken, I'm wondering, would that be CLBC?
No, I believe, and only Jennifer can answer this, but I would assume that she's talking about the Ministry of Social Development and Poverty Reduction, as we're talking about a PWD application. So that's the ministry that provides provincial disability benefits.
Right.
And obviously, other organizations under that ministry would include organizations like CLBC, which of course has responsibility for those supports that families that have children or adult children with developmental disabilities might access resources. And so CLBC would of course also accept, and in fact, I believe they have actual direct policy language that confirms and recognizes a Section 7 representation agreement as a vehicle for supportive decision making for the person with a developmental disability.
Great. And Holly's asking, how much does an RA7 cost?
I'll let you take that one, Audrey.
Well, you can actually make it for free in some
Yeah.
cases. So we'll list resources at the end. So especially for the Section 7, NIDIS is an amazing resource. When you see the forums on there, I personally have worked on some variations of them, all with monitors there. So you can access those for free. You know, if you're doing one for yourself and you want to add, you know, more complexity, different types of representatives, we can do that. We usually do a package for all of our estate planning files. I believe NIDIS also does, for $85, they will do a customized representation agreement for you. I don't know if that's both the Section 7 and 9 at this point, or just the Section 7, but that is an option. So there's lots of different options depending on the kind of flexibility you want, the different powers that you want for a representation agreement.
Yeah, and just for me, sorry, I was just going to say that it's also important to remember that the person developing the Section 7 representation agreement is in fact the person with that developmental disability or the diminished capacity. And so it would be that individual that would be effectively developing the agreement. So it would not be the representative that goes out and does that. It's actually the person that is the adult. So it's important to sort of understand the roles of the different parties. And again, I encourage everyone to look to NIDIS. And at the end of our PowerPoint, there'll be a direct link to the NIDIS organization as a resource available to develop those.
Also, the other thing is that there's been several resource parents who have been trained by NIDIS to actually do rep agreements for other families. So that's a possible resource too.
Yeah, there's a number of groups that now provide these supports outside of NIDIS, and so there's not a limit, but you know, again, there's even documents that you can access off the website, and I know many families will have what we call a Section 7 party at the age of 19, and have that all included when you're blowing out the candles as well.
Great. So back to the comité duties and responsibilities. The comité does have a duty to act reasonably and prudently, and not in their own best interests, but in the best interests for the adult for whom they are acting. So the comité is considered a fiduciary. They must always place the adult's interests before their own in managing the adult's affairs. For example, if they were making a large purchase for an adult, it would be prudent for the comité to obtain several different quotes and prices for comparison, or hire a professional to assist them. They must also keep good records again and retain, for example, those types of quotes and other financial records in their books. And to a reasonable extent, the comité must foster the adult's independence and encourage their involvement in any decision making. The court is also able to place limits on any rights, privileges, and powers of the comité, including needing written consent of the public guardian and trustee before the comité exercises any power. For example, the court could say, before you sell the adult's residence or any other real estate, or before you access a certain bank account, you need to get the PGT's written consent, or you need to get a court order in order to do that. So again, as we mentioned, the comité does have that real responsibility to keep good records, including hard copies of all statements and documentation of the adult's banking. They are allowed to hire a bookkeeper or an accountant to help them in setting up the commentationship record keeping, noting that not everybody has the ability to do that right off the bat. And they're able to continue to hire this accountant or bookkeeper to maintain the adult's accounts on an ongoing basis. So when a comité is appointed, every power of attorney and representation agreement made by the adult, unless otherwise ordered, is terminated. And again, commentatorship, we really want to emphasize as a last resort option. It's quite black and white. It really gets rid of all the sort of rights of the adult who is subject to it. But I'll now turn it over to Ken to kind of go over those general pros and cons of commentatorship.
Yeah, thank you, Audrey. You know, it's interesting. About 2 years or so ago, I was asked to do a similar presentation for FSI, and I had brought on one of the representatives from, or one of the lawyers from the public guardian and trustee, because we were concerned, both myself and the PGT and FSI, that families were being encouraged to develop committeeships for their adult children once they turn 19. And, you know, we really felt that it was important that families just, again, reemphasize that committeeship is really a last resort option, as Audrey's outlined. And we are very fortunate to live in British Columbia, where there are so many options available. And obviously, the utilization of the Section 7 representation agreement is a tool that is unlike any other province. So we're very fortunate. And so we try to encourage families to sort of look at what the options are, what the vehicles are, and, you know, is commentatorship absolutely necessary? Now, of course, there are going to be circumstances where commentatorship, you know, is necessary, and again, you know, that needs to be carefully scrutinized, not only because of the cost, but because of the finality of that and the impact that has on the adult, and then the future oversight and engagement of the public guardian and trustee. So we want to be really, really careful, but you know, there are circumstances, of course, where it's important to have that protection if there are real concerns for the safety and financial security of the adult, and where an individual's not has the ability to avail themselves of other planning tools, such as a representation agreement or a power of attorney. And the other added element here is that you do have the oversight of the PGT, which provides sort of a check and balance to ensure that the best interests of the adult is being formulated. Of course, there are cons, some significant challenges with comiteeship. Again, removing that autonomy, the expense, the time, the lack of privacy. When you enter the Supreme Court of BC, that now becomes a public matter. Everybody is aware of that development. So you lose that privacy. Comiteeship is not easily reversed. It's likely that there will always be a committee, although it is possible to have a committee removed at a later point if capacity returns. And then again, the oversight of the PGT. I said it's a pro, but it can also be a con. And the scrutiny of having a government entity involved in decision making to oversee that can be really frustrating for families as well. And it puts another layer of responsibility and bureaucracy on the process. So we want to ask ourselves always, is committeeship necessary? The decisions about financial affairs, what are they? Is the adult incapable of making those decisions? Would there be some benefit from, let's say, the public guardian for assistance and protection under those statutory property guidelines? And then, what would be the result if that assistance was not provided? And, have there been any other vehicles such as a power of attorney provided earlier? I mentioned earlier that it's not required for, an application for PWD benefits or, even CPP or pension, CLBC, and other health care related decisions. So, this is the question of, do we need comiteeship if there are vehicles that might assist in enabling that person once they turn 19 to continue to have, the support of a parent, and that age from going from 18 to 19, of course, changes the world. And, what we encourage is, just take a breath and confirm in your minds, is committeeship the absolute necessity at this point? And if so, why are we doing it? What is the reason for that?
Can we have one question from Joanne? She's asking, children that turn 19 with developmental disabilities continue to grow and develop. Can you develop an RA7 and then change it to an RA9? Yeah,
again, the big distinction between the RA7 and the RA9 is really about capacity. And remember that the RA7 provides for routine financial and healthcare decision making, whereas the RA9 is really purely about healthcare. It does not include financial decision making. So if you are going to be able to develop an RA9 and you can demonstrate that higher requisite capacity that you might not have in an RA7, then you may have that ability to also combine it with an enduring power of attorney to manage financial and legal affairs. But capacity will be the triggering point. So yes, the answer is absolutely. If capacity is in place, by all means, it's something that can be pursued.
Thank you.
So there's a bit of a hierarchy here about sort of decisions and healthcare decisions when we're talking about capability. And where there is not capability and a person is not able to make decisions and there is no vehicle, i.e. an RA7 or a Section 9 agreement, then we're left with the prospect of, committeeship of person, which really is about healthcare. And that would, of course, be determined by the court. If you're dealing with a healthcare provider, so your doctors or your hospitals or other medical providers, and they find or believe that you're incapable of informed consent, there are a number of vehicles. Obviously, the one at the high and top of the list, again, is that representation agreement and the representative that you've appointed. And then secondarily, it's that advanced care directive. Again, only if it applies to the specific situation at hand. So for example, I do not wish to be kept alive by, any mechanical devices. And then our sort of next level is that sort of temporary substitute decision maker, or what we call as the TSDMs, which is really determined by legislation, and it's intended to be temporary, and it typically follows sort of family-related relationships, so spouses, children, parent, sibling, grandparent, etc. There are obviously limits on a TSDM that are outlined here. So there are some real checks and balances, that the person is an adult. There needs to be some contact and no evidence of dispute. There's no authority for personal care decisions, no authority in an emergency situation, and obviously no general authority to refuse life-supporting health care. So how do we avoid, and I think that's really the key here, is how do we avoid committeeship or the need for a temporary substitute decision maker, and really the benefits of planning. So if possible, of course, we always want to have a Section 9 representation agreement and an enduring power of attorney. And that's where the adult, the person making the agreement, has full requisite capacity to understand the impacts and the nature of those documents. If capability is in question, then the next step is, can we develop a Section 7 representation agreement to enable that further empowerment around assisting you in making those routine health and financial decisions. And these can be very specific. The adult can provide specific decisions that each representative can or cannot make. And you may have representatives that simply deal with the financial side, and you may have others that may deal with just the healthcare side. And ultimately, the key here is, of course, that the adult is always in control of their decision making, but now they have the added benefit of support in making decisions, and that the representative is following the known wishes and beliefs of that adult. This is obviously a much more economic approach to the courts and the loss of privacy and the expense and that intrusiveness of committeeship. Giving somebody that authority to help them make decisions and ensuring that they're made on behalf of the adult with that diminished capacity. So, I think that is effectively, that slide there is effectively the scheme of personal planning in British Columbia. And I think it's one that everyone should carefully reflect on before they move to that last resort of committeeship. Now, Audrey's got a little bit of a sort of a summary slide here that I'll let her just kind of quickly run through if you don't mind.
Hey, there's just a question
Oh,
from
yes.
Barbara. On average, and obviously this is a spectrum, is a high-functioning autistic 19-year-old considered to have capacity to make a RA9?
Well, again, it will depend on the time you meet with that individual and having the opportunity to have a discussion with that individual. If you're a lawyer and you're being asked to develop a Section 9, the lawyer will meet with the adult with the high functioning autistic nature and make a decision. I have personally developed Section 9 agreements with varying levels of capacity. And ultimately, it's an individual decision. And I think it's not fair to the individual to make any sort of conclusions about their level of capacity until you've actually met with them and determined, what your sense is. And recognizing that, it's a legal test, it's not a medical test. The test is one of, do they have that understanding of what is the representation agreement? What does it do? What are its impacts? What is its reach? And what does it not do? So there needs to be a confidence that somebody understands what a Section 9 representation agreement is before making that conclusion. Now, I will say that I have clients that have full capacity and still don't understand that. So, it's our job as professionals to make sure that our clients understand that, and we need to be able to educate them on the rules, but also feel confident that they have that ability. And so I treat every client as, with the presumption of capability, unless it's demonstrated otherwise.
Thanks, Ken. So I know all the previous 25 slides were filled with text, so I thought it might be helpful if we had a bit of sort of a chart here and some visuals. I think Ken wasn't too sure about if the icons really represented, but they're supposed to represent financial affairs, legal affairs, healthcare matters, and personal care matters. So it was really difficult to find something that encapsulated personal care matters, but that's what the two people on the end are supposed to represent. So as you can see, commentateship does encompass all of these, but again, that's a last resort, so we want to avoid that as much as possible. If you're planning ahead of time, that combination of the enduring power of attorney and the Section 9 representation agreement really provides the broadest amount of coverage for financial affairs, legal affairs, healthcare, and personal care matters. Again, the Section 7 representation agreement does provide coverage of all of these areas, but to a more limited extent than the above two documents. The Advance Directive, again, covers healthcare, but again, very specific matters that are written in the advance directive, and again, much more limited than a representative appointed in a Section 9 representation agreement. And again, with the TSDM that Ken talked about, applies to healthcare, but again, to a more limited extent. So hopefully this kind of clarifies a little bit what we've been talking about.
And I think what's really interesting is you'll see, if you reflect on those green check boxes, the Section 7 and the committeeship basically have check boxes all the way across. And what I think is really important to note is the extremes of these two documents and or these two vehicles, and what the impact is, and how fortunate we are to have something like a Section 7 that really checks off a lot of these balances or a lot of these areas while recognizing, the limitations. So the trade-off is, I think, the limitations versus basically full-blown loss of autonomy.
All right, so as we mentioned before, there are some great resources out there. We do have some articles and previous presentations on our own website. Again, NIDIS is an amazing resource and just proponent of representation agreements. They have forums on their website, they have information, and they do have some ability to do custom forms as well. They also run a personal planning registry, which is somewhere you can, and this is optional, but it's somewhere where you can sort of upload your personal planning documents or even your wills, so that third-party organizations such as some hospitals and financial institutions have ability to kind of search the registry to see if you've made an agreement and you've uploaded it there in a situation where they don't know who to contact, who you might have given authority to. The Public Guardian and Trustee also has a website with lots of information on committeeship and adult guardianship. They have something called the PGT Comité Handbook, which really goes into depth on the duties of a comité, sort of the whole process and what sort of responsibilities that a comité has. Ken, anything else you want to add there?
Yeah, I just want to sort of articulate as well. I know I recently wrote an article that covers a lot of what we discussed tonight that I believe is going to be, or may have already been published through FSI, and perhaps Carrie or Karen can provide that link.
Yeah, I'll look into it for sure.
Yeah.
And just one quick question, in talking about the RA7, when could an RA7 possibly be challenged? Like if you have a rep agreement for someone that has an RA7, what would be circumstances that it possibly could be challenged?
I think that likely the most common area would be a sense that the person that developed the RA7 did not have the statutory or had not met the statutory test of a diminished capacity, and that perhaps the capacity was much more significant, or I should say the incapacity was much more significant. And that's a real fine balance, I think, for the person or the entity that is alleging invalidity of that document. And obviously an assessment, and I think to some extent a duty is placed on the person proposing or the entity proposing that the agreement has no validity and effect. Fortunately, I haven't heard a lot of these. They have come out a little bit, And the most common situation I have heard where, there may be an entity, whether it's a public guardian or whether it's an organization like CLBC, for example, that might be questioning the representative's authority for whatever reason. And there may be some element of investigation. I've heard some of those developments. Again, I think it's always a question of fact and determining and providing evidence to the contrary. And I think that, we always, and the intention of these agreements, and that's why there are limits on what can and cannot be undertaken by a representative. We're designed, to reflect wishes. And I think it's a really challenging area for a representative to be sort of challenging the authority of that document. So, but it's definitely a great question, and I think it's one that, as we see more Section 7 agreements in place, we're bound to have circumstances arise where questions arise about that validity of that document. I still think that the onus is on the proposer challenging the document to demonstrate why they believe that agreement is not valid. And I think it would likely then involve some element of PGT involvement and or investigation.
And there's a couple of other questions here. So a little confused. So would someone have both a Section 7 and enduring power of attorney?
Typically you would have one or the other. And the reason why you would have one or the other is that the Section 7 is really intended for somebody with diminished capacity, whereas the enduring power of attorney would be reflective of full capacity to make decisions. Both documents will enable financial and legal decision making, but the Section 7 will have limits, whereas the enduring power of attorney may have no limits. So really the difference between which one will be determinative of capacity of the individual granting either the Section 7 or the enduring power of attorney.
Thank you. And then one final question here is, what would happen if a significant injury or accident occurred with your high functioning child with autism and you had not organized any agreement?
Well, again, the starting point would be about capacity. So just because a child has autism or high functioning autism does not necessarily mean that they do not have capacity to facilitate a settlement. And again, if the personal injury lawyer, let's say, is comfortable in managing and taking instructions from the person with the disability, and they believe that person has capacity, then there may not be a need for any agreement. If there is questions about capacity, and I think this goes back to that earlier question tonight of the lady that was being told today that she needs to have committeeship to finalize a settlement. That's a question that then, suggests that capacity may be in question and that the nature of that settlement may exceed the limits of the Section 7 representation agreement. So there's a lot of questions that one would have to go through before making any determinations And I think that's what families should simply do, is not conclude without some further diligence what is next and what is necessary to resolve that matter. And I think that's where hopefully this session tonight has provided maybe not all the answers, but definitely hopefully a foundation of knowledge for families that will assist them as they tackle the future, for their children and for themselves for that matter. And I think, what we're trying to emphasize is that life is a lot more than just passing on. People are living longer and they're living full lives, and disability in itself doesn't mean that you're not going to live a good life. You just may need some tools and some supports along the way. And that's no different for a person that has a developmental related disability. We want to give you the tools to make decisions that will enable you and your adult children to have a good life.
And
Carrie,
then
I've just
one final question is, do rep agreements expire annually, or if a monitor representative cannot continue in their capacity?
I'll let you take that, Audrey.
Thanks. I was just about to say that, Carrie, because somebody also messaged that to me privately.
Okay.
So, yeah.
Okay.
So, thank you for that question. Representation agreements do not expire annually. And I do have an answer to the previous monitor question, which is relevant here. But if the representation agreement requires a monitor, or if there's no alternate representative and they can't continue to act, then it would be essentially ineffective, because then you wouldn't have somebody. So you'd probably have to make it again. Just going back to the monitor question. So if your RA7 deals with financial matters, you are required to have a monitor unless a couple of different scenarios apply. So if the representative being appointed is the person's spouse, or the public guardian and trustee, or a trust company, or the person making the RA7 is appointing 2 or more representatives who have to act unanimously to exercise that authority. In those 2 situations, you don't need a monitor, but otherwise, if you're dealing with financial matters, you do need a monitor in that circumstance. So going back to your question, Eva, so if the monitor is required and they're not available, then you likely would be looking at redoing the representation agreement.
Mm-hmm.
Thank you very much, Audrey, for that, because that was a question from the beginning too. So any more questions anybody has? I realize that the time is 8:33, and I would like to thank everybody for coming on this call and participating. I particularly want to thank Audrey and Ken. From what I'm looking in the chat group, everybody is finding this was extremely helpful and informative. And I will be sending out, I don't know if I can send out your PowerPoint. I don't know if you're okay with that or not. Okay.
Absolutely, yes.
Okay, so we'll be sending out the PowerPoint and all the other things. And we will also be sending out a Survey Monkey, so that you can, because FSL always likes to know how we can improve things or what other sessions. And I know that this one was a very popular one due to all the people on it. So thank you, everybody. And I hope you enjoy the rest of your evening. And you will get an email from me in the next couple of days.
Great. Thank you, Ken and Audrey. It was wonderful.
Thank you, everybody.
And Carrie, maybe
you.
we could stay on for a minute.
And I will be contacting you, Ken.
Looking forward to it, Carrie.
Okay.
Thanks, everybody.
I will be too.
It's been a pleasure.
Thank you all. Now wait, I can stop recording, right? Where's the recording? Here.
Just click on the bottom there, Carrie, where it says pause, stop recording.
You want to stop cloud recording? Yes.